Mastering the ability to pay an I-140 petitions. That's what we're talking about on today's Live at Lunch. My name is Emily Sumner with Sumner Immigration Law. Let's get into this very exciting topic. So first of all, what is showing the ability to pay? What does that mean in the context of filing an I-140? The I-140 petition is, generally speaking, the second stage of the employment-based green card process. So the first stage is the perm labor certification application filing. That is a whole process. Right now, it is taking 2 years, sometimes longer than 2 years, to get through that process, really longer than 2 years. I would say closer to 2.5 or maybe even 3 years from the time you start the process to the time that you get to have the labor certification approval. So if you go through this process, you want to make sure that that second stage of the process, the I-140 petition, will be successful. Otherwise, you may have to start all over. The reason I say that is because the information on the perm labor certification sets the foundation for the documents and the information that you'll have to prove on the I-140 petition. When you file the I-140 petition with USCIS, there are three main things that you have to show as the employer. One is you have to show that the company has the ability to pay the proffered wage. That's what we're talking about today. You have to show that the foreign national beneficiary meets the requirements of the position. So document their education, their experience, any special skills, and you have to show that the position is available. That's generally just a letter from the employer. So how do you document the ability to pay the required wage? So the required wage is going to be the prevailing, well, really the proffered wage. The proffered wage is either the prevailing wage or higher, whatever the higher proffered wage is. And that is set as part of the perm labor certification process. So part of that process is obtaining something called a prevailing wage determination from the Department of Labor. That itself takes several months to get through. That's part of that 2+ year process I was talking about. But you'll get a determination from the Department of Labor that says, okay, for this particular offered position, you, employer, have to pay at least X amount per year. So let's say, for example, for purposes of this conversation, that your prevailing wage determination is $100,000. That means that as an employer, when you file the I-140 petition, you have to show that you as the employer have the ability to pay that wage of $100,000 from the priority date, which is the date that the labor certification application is filed going forward. So remember that we're submitting this documentation documenting ability to pay with the I-140 petition. So that is going to be probably, a year, 18 months later, probably 18 months at least later after you submit the labor certification. However, in our practice, we always have this conversation about ability to pay when we first start the perm labor certification process, because that wage is set during the perm labor certification stage. So you do not want to get through that whole perm labor certification process and then find out that you as the employer can't document that you have the ability to pay the prevailing wage. So how do you show this? There are three major ways that USCIS will accept in terms of documenting your ability to pay the prevailing wage. One is the net income of the company. 2 is the net current assets of the company. And 3 is to show that you are actually paying the foreign national employee that amount already. So going into each of those in a bit more detail, when USCIS is looking at the net income or net current assets of the company, remember, we're talking about net. So net income is the bottom line, literally. It is not the top line. It's not the gross revenue, but it's basically what the company's profit is. USCIS will only accept certain documentation to show this. You cannot just print out your profit and loss statement from QuickBooks. It's not going to work, unfortunately, or wherever you do your accounting. Instead, USCIS will look at the company's most recent tax returns or audited financial statements or an annual report if the company is publicly traded. So remember that you have to have certain documentation to prove these numbers. You can't, like I said, just print off a financial report from your own system. So looking at the net income, looking at the net current assets. So net current assets, I did not know this until I started practicing immigration law, but net current assets, the word current means convertible to cash within a year. So it is something that is like cash itself, or accounts receivable that are receivable within a year, depending on how you do your accounting, Bottom line is this information is going to be on Schedule L of the corporate tax return. And remember, you're only looking at net current assets. So you're going to add up the current assets again, and it'll specify on the tax returns. And this is something that we can help you with as your immigration lawyer if we're working with you on this process. That you want to look at the current assets, total those up, total up the current liabilities, and then subtract the liabilities from assets. Hopefully you come up with a positive number, and that would be your net current assets. And a lot of times we are able to use that for a company or for a client, even if their net income is not necessarily sufficient. And then finally, you can use and again, for net current assets, USCIS will only look at the company's most recent tax returns, audited financial statements, or an annual report. Then finally, the third way that you can generally show ability to pay is by showing that you as the company are actually paying the employee that amount already. So that would be documented through their W-2s, through pay stubs, documentate information like that. When we use that method, when we show that the company is already paying the proffered wage to the employee, we submit the employees, like I said, their W-2s and their pay stubs. We also calculate it out for USCIS. We don't want them doing their own calculations, their own math. We literally write out, they're earning X amount per month. They get paid twice a month. And we write out the math equations for them to show that they're actually earning the full amount. If we do that, we also include the company's tax returns because that's listed in the regulations. One thing to keep in mind, a couple of things to keep in mind. So those are the three major ways. Like I said, net income, net current assets, or the showing that you're actually paying the employee that amount now. However, there are a couple of exceptions. One is both of these are in the regulations, but in the regulations, it says that if a company has more than 100 employees, you can use a letter from the CFO. So that is something, again, that we've used before, depending on the size of the company, a letter from the CFO just saying what the company's income amount is. In addition, there have been times over the years, and this is discretionary, it's not guaranteed at all, but there are times when a company has a lower net income for a particular year, and there's a specific reason for it. And it's not their historical trend, it's an anomaly for them. There is case law that says that you may still be able to show ability to pay if you can show, generally speaking, if you can show a trend over time that shows they generally would be able to prove the ability to pay, but for this very unique year, not very unique, but this unique year, this unique circumstance. So for example, if COVID hit, and this is not, when I give this example, it's not meaning that if you use this as a reason that it's absolutely going to be successful, it just depends. So if you can argue, tell the story, the accurate story that when COVID hit, the business was affected and this was the reason it was affected, exactly how it was affected. Look at these years surrounding it, on either side, and our numbers were much better. We have the ability to pay then. It was this one year because of this unprecedented global pandemic, as an example. There can be other reasons as well, for sure. I've made that argument successfully even in pre-COVID years and for other reasons. But again, that's discretionary and it's absolutely not guaranteed that USCIS would accept it. But know that there's case law that supports the discretion, use of discretion, positive discretion by USCIS. So what are some pitfalls to avoid in this process? One is not planning ahead. As I said a few minutes ago, when we began the perm labor certification process for a client, for a company and their employee, we have this conversation from the very beginning and say, hey, at the I-140 stage, we're going to have to prove ability to pay. Let's look at your tax returns. They may not look the same now as they're going to look in 2 or 3 years when we actually get to the I-140 stage, but let's have that conversation, make sure that they understand, see if it's within, if it's within a practical, if it's likely to happen, if their taxes down the road are likely to be able to show the ability to pay. Make sure we have that conversation. We don't want to obtain a prevailing wage determination for, $200,000 a year when the person is not employed and the net income historically has not shown that. We want to make sure that we have realistic expectations. The second pitfall to avoid is relying on gross income. That's something that we try to communicate clearly to clients is USCIS will be looking at net income, not gross income. And then failure to include appropriate documentation. over the years, I've seen I-140 denials that have been prepared by other individuals, not our office. And a lot of times the denials boil down to incorrect documentation being submitted or not clearly presented. Like I said, you don't want to leave room for USCIS to apply their own logic or do their own mathematical calculations. You want to make sure that you present really clear documentation. And that means including pay stubs that are consistent, W-2s that are consistent, with what they're actually being paid and what you're saying in the H-1B petition or other non-immigrant visa status petition, if the person is working in a non-immigrant visa classification, and making sure that you're submitting tax returns if that is what you're relying on, rather than profit and loss statements, like I said, or audited financial statements. So it's critically important that you submit the correct documentation. So that's something that we can help with. We help clients with this every day of the year, almost, at least every day that we're working. We help clients navigate this green card, employment-based green card system, and we would love to help you as well. If you have questions or if you're thinking about starting the process for an employee, we would love to have a chat with you and learn how we may be able to help. Right after this video, you will see contact information for how to contact our office. If you have found this video helpful, I hope you'll share it with a friend or a colleague. Make sure that you click like, that you put a comment, put a question. I'm happy to answer questions if I can, and make sure that you're subscribed to this channel. Otherwise, my name is Emily Sumner with Sumner Immigration Law, and I hope to see you again next Tuesday for Live at Lunch at noon Eastern. We help clients with employment-based and family-based immigration matters around the United States and around the world. Until next time.